Next, the final thing on our agenda is the Legislative Review Committee recommendations, and is Chair Brian Considine available?
Yes, Mr. President, I'm here.
I see you. Thank you, Chair Considine. So this is the Legislative Review Committee. As a reminder to the Board of Governors, we have two legislative committees. We have the Legislative BOG Committee, and we have a committee that's near and dear to my heart, the Legislative Review Committee, that I've been a part of for, like I said, nearly 20 years. I'm glad that Chair chairing this year. I did attend the first meeting. It was a very good meeting. Today we are going to be discussing the business law section's proposed amendments to the Washington Nonprofit Corporation Act. I warned the Board of Governors earlier today that that is a rather complex act. It's lengthy. It's in excess of 200 pages, I believe, and it's very dense. The committee, the Legislative Review Committee, had a lot of good questions and comments about it, but I'll turn it over to you, Chair Considine, for a description you would like from the Board of Governors.
Sure, thank you. And I'm going to plan to be brief. I believe the representatives from both of those subsections are here, and they clearly have been the ones putting in all the time on it. I will say for members of the BOG that don't know me, my name is Brian Considine. I am the chair this year, been on the committee for, I want to say this is maybe my 5th or 6th year. My day job, though, is this. My day job is I'm the legal and legislative manager for the Washington State Gambling Commission, and I basically work with the legislature, the governor's office, and everything that's legislative in my area of policy. So felt that I've always enjoyed this committee of being able to kind of stretch what I do to help the Board of Governors. And I think these two proposals are good proposals, and I'm really happy. We had a nice, robust discussion about both of them. We have a much bigger committee this year, which was fun to have a lot of input. So I think it's getting vetted a little bit different, a little bit more thoroughly, but it's still good. I don't think we did anything, poorly in the past. It's just more people, you get more input. And so you have the Business Law Sections Corporate Act Revision Committee. And I think Eric DeJong is on the line possibly for that, but if not, I'm happy to talk to it a little bit. And then the second one, as the President said, the Nonprofit Corporation Committee. Now, it's a long bill. David Lawson, I think, very well may be on the line. David is one of the most knowledgeable people I've ever run across. I actually know the Nonprofit Corporations Act quite well because I've had to deal with it both as president of a small nonprofit, but also my agency deals with a lot of nonprofits. I think the one thing to keep in mind, which kind of helps set why it's so long, is we're recodifying the Nonprofit Corporations Act. So a lot of stuff that's currently in the Nonprofit Corporations Act is having to get cut and pasted into yet a new codification of it. So that's another reason why it's long. So you see a lot of new sections, but that doesn't necessarily mean that everything that's in this is going to be new. But I think it's better to hear from the folks who have put the time into these proposals. I do commend them to you, and we do recommend that they both be considered WSBA pieces of legislation, or that you approve them, that you take them on. And at this time, I'm happy to answer if there's any general questions, but I'd kick it over to Eric and to talk about the proposed changes to the Washington Corporations Act first, and then to David about the nonprofit, or however you wish to do it, Mr. President.
Thank you, Chair Considine. I've only known you for 5 years, and I apologize for mispronouncing your name, Considine. I'm not seeing any hands from the governors, so let's go ahead and ask Mr. DeJong to present first.
Great. Well, thank you, President Sacchetti, and other members of the Board of Governors for the opportunity to present a proposal to amend a number of sections of the Washington Business Corporation Act. This proposal was developed earlier this year by the Corporate Act Revision Committee. I've been a member of that committee for 20 years and have been co-chair with Mike Hutchings of DLA Piper for about the last 5 years or so. And hopefully each of you has had the opportunity to review the explanatory memo that we put together that specifically lays out the amendments we're proposing and the background on those amendments, but I'll be highlighting them all in my presentation today. Generally, the proposed changes deal with the use of email and other forms of electronic communication for purposes of providing notices and other corporate communications under the Business Corporation Act. And our proposal specifically touches on 5 sections of Title 23B, Section 01400, which terms that are used throughout the Act, Section 410, which governs notices and other communications, Section 420, which deals with householding, and I'll explain what that means in a minute here. Section 07040, which deals with shareholder approval by written consent in lieu of a meeting, and Section 08210, which deals with director approval by written consent in lieu of a meeting. I'll start by talking about the changes to 01400. These are pretty technical in nature and are really just intended to provide a little bit more clarity on the interplay between the definitions of electronic record and electronic transmission on the one hand, and section 01410 subsection 10, which deals with the use of electronic media that wouldn't otherwise fall within those definitions. And I guess by way of background, embedded within the definitions of electronic transmission and electronic record is the concept that it has to be retrievable in paper form by the recipient through an automated process used in conventional commercial practice. And what subsection 01410 allows for is for a sender and recipient to agree to the use of forms of electronic communication that wouldn't otherwise fall within those definitions. So for example, texts, voicemails, and as I understand it, certain kinds of web-based collaboration applications wouldn't ordinarily fall within the definition of electronic transmission or electronic record, but if both parties consent to the use of those electronic media, then they can be validly used for purposes of giving and receiving notices and other corporate communications. So as I mentioned, the change in subsections 13 and 14 of section 01400 are really just technical in nature and are designed to provide a little bit more clarity on how those concepts are interplay. The changes to 01410 are probably the most consequential of those that we're proposing. And 01410 is the section that governs notices and other communications between business corporations and their shareholders and directors. By way of background, since 2002, this section has permitted delivery of notices by email and other electronic transmission so long as the recipient affirmatively consented to the use of that means of delivery and provided an email or other electronic address to which notices may be sent. Now, earlier this year, the requirement of consent was softened a little bit in that the section was amended to provide that director consent would not be required if a corporation's articles of bylaws require or permit notices to be sent to directors by email or other electronic communication. The requirement for shareholder consent to be able to use email or other electronic transmissions for purposes of providing notice is still there in the statute. So what we're proposing is to eliminate the requirement for affirmative consent entirely. And if this change is made, then email or other means of electronic transmission would become a default method for delivering notices and other communications, much like the US mail is now. And in this respect, we're proposing to align the default rule with respect to email and other electronic transmission to the approach that's taken in Delaware, which is, as you probably all know, is a pretty well recognized as the leading corporate jurisdiction in the U.S. And Delaware made this similar change in 2019. And I guess I'd point out that there are many other states that allow by default corporations to use email and other forms of electronic transmissions for purposes of providing notices. The proposed amendment does build in some protections. First, email and other electronic transmissions may not be used to send notices and other communications to any shareholder who has objected to receive notices in that manner. And second, if a corporation attempts but is unable to deliver 2 consecutive notices to a shareholder or director and becomes aware of those delivery failures, it can no longer send notices or other communications to that shareholder or director. Moving on to subsection 11 of section 410. This subsection 11 has been part of the Washington Business Corporation Act for over 10 years. And basically what it does is align our notice provisions with the SEC's e-proxy rules that public companies can use for purposes of delivering proxy statements and other shareholder communications. The changes that we're proposing to this subsection are technical in nature and really don't represent any fundamental change to the existing statute. Moving on to section 01420, this is the section that deals with householding, which is a code word for the ability of a corporation to send a single notice to multiple shareholders sharing a common address. And the changes that we're proposing are mainly to align the language of this section with the analogous provision in the Model Business Corporation Act. And I'll just briefly mention, probably many of you know that Washington is a Model Business Corporation Act statute that basically is modeled after the MBCA that the ABA Committee on Corporate Laws promulgates and updates from time to time. The most recent major revisions to the MBCA were in 2016. So one of the things that the committee is doing is just bit by bit looking at the changes in the 2016 version of the MBCA and incorporating those where we think it's appropriate. So I guess the most consequential thing from a substantive standpoint that we're adding to 01420, which again aligns with the MBCA, is that it allows for consent to householding of notices to be implied if a corporation sends the shareholders a notice that lets them know it intends to household and none of them object within 60 days. And I guess I'd also point out that that aligns our statute with the householding rules that were adopted by the SEC in the early 2000s. And then last, we're proposing basically 2 identical changes to section 07040, which governs shareholder approval by written consent in lieu of a meeting, and section 08210, which deals with director approval by written consent. And in both cases, the changes are just intended to clarify when a consent is deemed to be executed by reply email or other electronic transmission. So we're not really changing the law here. We're just trying to provide additional clarity on how that works. So that wraps up my presentation of our proposal, and I'd be happy to entertain any questions that anybody might have about these proposed changes.
Thank you. I do see we have one governor that has a question? Other governors, if you have questions, please raise your virtual hand. I'll recognize Governor Williams-Ruth.
Thank you, Mr. President. So I will confess that anytime something says we're going to be following the model acts or model codes, it rises to a level of great suspicion for me, as I'm not a fan of them in general. In this case, I have a couple specific questions relating to compensation for directors. And being familiar with 2403, the same language was there, but it was contained within other paragraphs or subsections. For example, 2403, 0304 is what is going to be now the new section 1407, which pulls out and highlights that nonprofit corporations can pay a reasonable compensation to their members, directors, and officers. And I was just curious as to why it's necessary, because then it also happens again. And for those who didn't memorize this statute in the 200 pages, it's in the materials at page 148. And then again, I'm going to be talking about page 189, which is section 2412. So I'm really curious as to why that is being called out. And then the second question I have relates to the number of directors. On page 183, section 2404 says that anything that's not a charitable nonprofit can be one or more directors. But then later on page 194 at section 26013, it says that a minimum of 2 people is required because there must be a president, treasurer, and secretary. And a president can also be treasurer, but the secretary must be a different person. So why are we revising and cleaning up an act that says technically you can have 1 director, but actually when it comes down into the details, it says you must have at least 2 because there has to be a separate president and a secretary? Thanks so much for all your hard work.
Well, I will defer those questions to whomever is actually presenting on the Nonprofit Corporate Act proposal. I've just presented on the Washington Business Corporation Act, and that's 23B. Your questions relate to 2403. So I guess I defer to, is it David who's going to be presenting on 2403?
Yeah, sorry, this is Brian. I think, Mr. President, it'd probably be best to put a pin in those. I think they're good questions, but David Lawson is completely capable of answering those questions. And it might be good for him just to hit on those as he gives an outline of the Nonprofit Corporations Act, if that works for the Board of Governors.
That sounds appropriate. Okay, so let's, Governor Williams-Ruth, we'll just wait for Mr. Lawson to give his presentation. And then if your questions aren't answered, we'll circle back. Any other governors have any questions for Mr. DeJong? All right, well then why don't we move forward with Mr. Lawson for your presentation on the second piece of legislation.
Thank you, and good afternoon. I appreciate all of your having us before the committee today or before the board to present a proposed suite of revisions to the Washington Nonprofit Corporation Act. As Brian mentioned, this is a big package because it is a wholesale replacement for the current Washington Nonprofit Corporations Act. And there are some provisions that carry over and many that do not. We started as a base with the 3rd edition of the Model Nonprofit Corporation Act, which is from 2008. And believe it or not, this committee has been working on the proposal almost since then. I joined the committee in 2012, at which point its work was substantially along. But we now, to make a long story short, finally have a bill that we are proud of and want to bring before the legislature. So there is obviously a lot in this bill. It's 260 something pages, and well over 150 of those are actually new provisions. So there's no way that I can walk you through every single provision in the Act during a presentation of this scope. So in order to focus on what's most important here, there are a lot of important things, but I want to tell you a little bit about the goals that the committee had in putting together this bill, and then some of the major features in the bill that we're trying to get over the finish line to improve the law governing nonprofit corporations in Washington. So there are three big picture goals here. The first is modernization. The current Nonprofit Corporation Act is over 50 years old and is missing a lot of elements that you find in statutes that have been drafted more recently, and also has a lot of practices here and there through the statute that we don't believe reflect currently recommended practices in nonprofit corporation administration or governance. The second major goal is to clarify and strengthen the provisions of Washington law in general relating to the protection of charitable assets specifically. The current Nonprofit Corporation Act is largely, not totally, but largely silent on the treatment of charitable assets. For the most part, that topic is deferred to provisions of the Washington Trust Act that relate to charitable trusts. Those provisions, for a variety of reasons that I'll get into in more detail in a minute, are something of a poor fit for protecting charitable assets held by nonprofit corporations that are not trusts. And so we have a variety of new provisions that are specifically intended to advance that goal. Then finally, one area where the current Nonprofit Corporation Act is particularly lacking, in fact, there are barely any provisions in it, is with respect to membership in membership nonprofit corporations. This is an area where I think all of us who work day to day in the nonprofit bar are experiencing confusion, both from our clients and for ourselves on a regular basis. It's an area where there's a lot of issues out there where we are sort of in the Wild West, and we want to bring to Washington membership provisions that are more typical of what we see in states with newer acts, and that help organizations actually figure out what the rights, obligations, powers, and duties of their members are. And so those are the big picture goals. And having said all of those, I want to zoom in now a little bit on a few specific priorities that were really important to us in drafting this bill. The first is going to sound familiar from Eric's presentation. We wanted also to update and modernize the rules around electronic communications, and now also, since we've been in the pandemic situation, electronic meetings. So we have rules in this draft act governing electronic communications that are very similar to the ones that Eric outlined that CARC is posing for the Business Corporations Act. We do not require consent in advance in every case to send a communication or a notice by email, but we have the same protections against bad email notice that Eric described with respect to the proposed CARC changes. In other words, if a notice fails delivery twice, then you have to go back to the drawing board and send notice in some other format. And if somebody withdraws permission to provide electronic notices, then you have to go to some other format. But in general, if you have an electronic address for your directors or your officers or your members, and that electronic address has been provided to the corporation and is working correctly, notices can be delivered to that electronic address and be valid without having to have an expressly signed consent in the records. We think that will result in many more communications and notices actually being in compliance than occurs today. So that's one important thing that I want to zoom in on. Another important piece that it's really important to focus on, we are very much streamlining and updating a lot of mechanical rules related to how Secretary of State filings are handled and how corporations maintain their basic infrastructure. The update that 2403 received when the Uniform Business Organizations Act 2395 was passed was incomplete, and we are trying to square that circle and make sure that everything is consistent in terms of Secretary of State filings and reports that are filed by corporations. So moving on then to, in particular, charitable assets. So the current situation that we've got is that charitable assets held by nonprofit corporations are governed under the provisions of the Washington Trust Act related to charitable trusts. And there are a couple of key issues with this that we wanted to address. One is that trustee duties with respect to assets held in charitable trust are very different from the duties of nonprofit corporation directors. And in today's environment, it's not always totally clear which duties apply. We see this as something that has a bit of a chilling effect with respect to service on nonprofit boards, and that also inspires questions in a lot of our nonprofit clients and their directors about exactly what their obligations are. So our draft act makes clear that that charitable assets held by nonprofit corporations that are not in trust are subject to their own clear protection regime. The duties of directors are the duties of directors, which especially means that the directors have the benefit of the business judgment rule. We also clarify the supervisory authority of the Attorney General, which currently derives from the Charitable Trust Act and is and involves anything that could affect the proper administration of a trust, which is a vague term. We have much more precision in the proposed act about how the Attorney General can supervise charitable assets and enforce the rules related to charitable assets. There are specific procedural protections that are derived from the way that the Attorney General is allowed to investigate under the Consumer Protection Act. And we also have specific procedures for modifying gift restrictions on gifts that are held by nonprofit corporations that are intended to dovetail closely with the Uniform Prudent Management of Institutional Funds Act 2455 RCW. Right now, there is occasionally some ambiguity about whether we should be applying the provisions of 2455 or the Trust Act or both to charitable assets that are held by nonprofit corporations and how they should be managed and how gift restrictions should be modified. So all of that is clarified. It's intended to ensure that the rules are clear and make sense for nonprofit corporations rather than for charitable trusts. So then diving into the membership provisions, we have right now essentially a provision that says, well, you can have members and you can make rules about the members, and that's it. That's more or less what's in 2403 today. Oh, and you have to have an annual membership meeting. So our provisions that are in this proposed act set out default rules, most of which can be changed through the corporation's governing documents regarding what the rights of members are, when members do and don't have the right to vote, when they do and don't have the right to approve fundamental transactions, and also exactly how member voting works. We have procedures in here that are clearer than today's with respect to voting at a meeting, unanimous consent of the membership, and membership votes by written ballot. All of those provisions we think will cut down significantly on confusion relating to how members relate to the corporations of which they are members. Fully beyond all of those specifics, we have many edited provisions that are intended to get us closer from the 1969 world of 2403 to modern understandings about how nonprofit corporations should be governed. That's pretty much the big picture. And I want to make sure that we have time also to get to specific questions such as those that have already been asked and those that might be out there. Judy, before we get into the Q&A, anything else to add? Judy, you're on mute.
I can never quite get the cursor over there fast enough. And I came in a bit late, and I'm sure you did a fabulous job summarizing the act. I don't think I have anything else to add. Thank you.
So, oh, I'm sorry, go ahead.
I was just going to say, Mr. Lawson, if you had additional comments, go ahead. Otherwise, we'll open it up to questions, or you could just address Governor Williams-Ruth's questions from earlier.
Sure. Governor Williams-Ruth, I'm sorry, I wrote something that I can't now interpret. What was your first question? I have the second one.
The first question dealt with why are we breaking out into separate sections the issues about compensation for directors instead of where they had been put together with, like if you look at 2403-030, it was put together. Now it's its own separate section being codified. And I'm personally concerned, given the 26 years I've worked with nonprofits, that if people who aren't attorneys that are looking at that are going to see, oh, hey, I should be being paid as a board of directors member. And I know that because the fact that when I was having conversation with one of my HOA members, they thought, wow, what a great idea. Didn't know we could do this.
Sure. So that's a good question. I should point out, just as a matter of sequencing in the act, that the provision providing for reasonable compensation for directors immediately follows the provision setting out what is an illegal distribution. And I think it was a choice just based on the fact that the unlawful distributions provision was getting long and complicated. So we wanted to have one section there that specified what an illegal distribution or an unlawful distribution was. And then you see that there's a list in there of a variety of types of unlawful distribution and then a variety of exceptions to the unlawful distribution rules. And then one of those exceptions is the reasonable compensation provision. And we do have in there that compensation needs to be reasonable under the circumstances, along with some special rules on property held for charitable purposes and charitable corporations. So to your second question, what's the deal with one director versus needing two officers? So not every officer has to be a director. And in fact, it's a reasonably common structure in private foundations that you'll have one director who is the founder, and then somebody they hire serves as the secretary and the treasurer. So you can have a corporation that has one director and then a separate person who is not a director serving in the officer position of secretary. And that person as an officer also has fiduciary duties to the corporation.
That's it. Let me just add that that's an addition that we've made to this revision of the act that wasn't clear in the previous act, which is that officers also have fiduciary duties to the corporation.
That's right.
And I guess why would having one director, even if there's other officers with a fiduciary duty, why is one director a good idea? I just don't understand the rationalization behind that.
So one director is a pretty common fact pattern today in nonprofit corporations that are intended to be private foundations for federal tax purposes. Those are basically pools of money that are subject to specific federal tax rules on how they are distributed for charitable purposes. And many individuals have founded their own private foundations and serve as the sole director. There is a debate in the tax exempt organizations bar about whether there should be a requirement that private foundations have 3 directors. But we felt that for the private foundation form, the 1 director pattern is something that can work. Now you'll notice in that same section, there's a requirement that anything that's going to be classified as a public charity under federal tax law has to have a minimum of 3 directors. That is new in Washington law with this proposed act. Right now, in theory, you can form a public charity with 1 director, although if you do so, the IRS will probably object.
Thank you.
Sure.
All right, governors, do you have any other questions for our panelists? Not seeing any questions. We have 2 proposals, both, I believe, sponsorship. They're asking for sponsorship. I'll entertain a motion for one or both.
Move we approve and recommend both.
All right, I have
Seconded.
I have a motion from Governor Grabicki. Do I have a second?
Seconded.
Governor Clark has seconded. Any further discussion? All right, I will move forward with and that's on both bills, Governor Grabicki?
Yes.
All right, I'll move forward with a roll call vote. Excuse me. Governor Abel. Governor Angeville.
Aye.
Governor Boyd.
Aye.
Governor Clark.
Aye.
Governor Dresden.
Aye.
Governor Grabicki.
Aye.
Governor Higginson.
Aye.
Governor Kang. Governor Knight.
Aye.
Governor McBride.
Aye.
Governor Peterson.
Yes.
Governor Pertzer.
Aye.
Governor Williams-Ruth.
Aye.
Got 11 ayes, no noes, no abstentions. Thank you, Mr. Lawson and Mr. Chair Considine and Mr. Zhang. I appreciate your presentations this afternoon. Good luck with this legislature. I understand that it is most likely going to be virtual, at least for a little while. So that's going to be different for everybody. But hopefully that doesn't lessen our sponsorship or our bills in any way.
Thank you for hosting us, Mr. President. I really appreciate it.
Yes, thank you.
Thank you.
All right, that is the last thing on our agenda in the fastest Board of Governors meeting in the history of the organization. It's 3:51. What I thought I might do is tomorrow we have public comment scheduled for some point tomorrow. It's not standing out to me, but there will be public comment tomorrow. We might as well take some of this time up this afternoon too, in case anyone would like to make public comments. I'll open that up to the not only the Board of Governors, but also our guests who are attending. Hopefully our guests can raise their virtual hand if they have anything further to want to say. I'll be a little bit more lax on time limits, at least at this time, since we're at the end of our agenda items.
Rex, do you want to remind folks who are on the phone how to raise their hand?
*9.
*9.
Is it R9? R is in
Star.
star 9. Okay, and so I do see that we have several visitors. So I encourage you, if public comment, if you'd like to say a few things about anything that we've done today or what's on your mind, I appreciate you raising your hand. And governors, if you have any thoughts that you would like to convey, I'll have you raise your hand as well. So I have a hand raised with the area code 206 and ending in 518. Whoever that is, you're recognized. You may be on mute.
Rex, how do they unmute themselves?
*6.
*6.
Okay, there we go. Hey guys, this is Jim McPherson. I'm sorry, I'm actually in my car. I was reluctant, but since you did have some extra time, can everybody hear me now?
Yes.
We can, yes, go ahead.
Okay, I did try to make a comment that I did not want to be misinterpreted during the very beginning of this afternoon when you talked about the discussion involving the comment that was made on June 26th by Carla. Obviously, I was at that meeting. I had a similar reaction to many of the people there. And the comment I wanted to make today is that if there was something I thought might be misinterpreted in the written material that you presented, is that starting with number, it seems to be a self-serving statement the Bar Association has been doing in this area.
Mr. McPherson, you're cutting in and out. We're only getting portions of your comments.
Oh, I'm sorry. Well, maybe I should just type something up and send it to you. Should I try again?
Go ahead, and if we have trouble, we can explore something.
All right. Well, I'll summarize a little bit of what I just said. I wanted to comment on the discussion about the reaction to Carla's comment on June 26th. I was present at that comment. My thoughts today were that your numbers 4 and onward on that statement seem to be a self-serving comments by the bar about what a terrific job we've been doing in this area for the last 3 years. And I think that takes away a little bit from the purpose of that statement. I was very, very encouraged by Carla. Once again, I think this is the 3rd or 4th time that she has publicly apologized and discussed her growth in this area. That's what I would prefer to focus on in a statement like this. I feel like it was appropriate. I'm not objecting to it, but I do think there's a potential for it to be misinterpreted by some as a way of the bar saying, look what a terrific job we've been doing, when in fact, perhaps we haven't been doing as good a job as we might have. Not that Carla's comment is a reaction to that or a reflection of that, but that that was my thoughts. And I probably would have just stopped by saying we're sorry that it happened and we'll try not to do it again. But so I'm thank you for the public comment. I hope anybody got to hear that.
Thank you, Mr. McPherson. We appreciate that. We did hear at that time, and you did not cut out. So thank you.
And I do want to thank Carla once again, because I think she's making a yeoman's effort to rectify a very difficult and unfortunate situation. Thank you. And I'll mute myself now.
Thank you, Jim.
Thank you. Okay. I'm not seeing any other hands. Rex, do we have anybody on the phone that I'm not seeing that might?
No.
Rex?
Sorry, no hands currently up. Again, to raise your hand, *9. To unmute, *6.
And I'm going to wait.
I do have a fact check update for you.
Okay, go ahead.
So, immediate past President Rajiv Majumdar had a meeting scheduled July 24th, adjourned at 2:18 p.m. Scheduled to adjourn at 6 p.m. So, just, we like facts around here.
I retract my statement.
But it has been a very smooth meeting. I do give you that. It's well done. Job well
It's
done.
something to aim for tomorrow, Kyle.
That's right. Okay. What did you say, Rex? 2:18?
That is correct.
All right. Tomorrow we're ending at 2:17.
When I think it should be more based on, it was scheduled for a 6 p.m. adjournment. So, I mean, almost 4 hours shaved off that time. So
4 hours.
Mr. President, there is a question in the chat.
There is a question. Former Governor Andrea Jarman. Her question are, what are the next steps now that the Board of Governors has met with the MBAs? So earlier today, I'll mention this, and if other governors want to respond as well. Earlier today, we did host a period of time for the Board of Governors to respond. That followed primarily the meeting with the MBAs on October 20th. We mentioned that what we did today, what we do today, is not in any way the end of the process. As we mentioned earlier, our commitment to continued diversity, equity, and inclusion training goes on throughout this entire year. We're committed to educating ourselves. We're committed to continuing the training, the development and learning. And we, at least from my own opinion, we feel that this is a step forward, not the end, and we'll continue on to explore those issues and continue to be better. Immediate past President Majumdar, I don't know if that's your hand or not, but if anyone has any thoughts on continued training, continued working with the MBAs, working with our members, that's all what we can do. We have been doing for these last few months, and will continue to do. So I don't know if that answers your question, former Governor Jarman, but it was discussed earlier today.
And also, I just want to say that there is a letter that is going out to the MBAs that we discussed, correct? Am I correct on that?
A letter in addition to what we've adopted today?
Right. I'm sorry. It was an adopted resolution, and I'm not sure if former Governor Jarman has seen the materials. But yes, it's an adopted resolution. I refer to it as a letter, but obviously it will get to the minority bar associations directly, I would think.
Yes, it will be made available, and I don't know that it's called necessarily a resolution. I think we've been referring to it as a response. I don't know that it has a title. Governor Higginson?
Well, I just thought that since Andrea's on the line and Governor and she's the co-chair of the Diversity Committee along with Governor Angeville, and Governor Angeville said in response to my question earlier that she would chat with her co-chair to find out if there'd be any issue with sending the Diversity Committee agendas, minutes, and materials to the entire set of governors. I'm wondering if Andrea might have a comment about that.
Actually, Governor Higginson, we've already discussed it via text. And
more efficient than I dreamt.
So perhaps former Governor Jarman and my co-chair could confirm that we have no objection to that.
Good afternoon. My audio has been giving me trouble today, which is why I was using the chat feature. Yes, Governor Higgins, we don't have any objection to that. I think we welcome that. The more opportunity for communication and involvement and education around these issues, I think it's really, really important. And I'm encouraged and inspired by your desire to participate.
Well, if I may just say, Mr. President, I want to say thank you, and I look forward to that continuing education.
Thank you, Governor Higginson, and thank you, former Governor Jarman. All right, with that, it's 4:02. I don't see any other hands. Nothing further in the chat. Last call. I don't see anything further. Then I will go ahead and adjourn our meeting for today. We have a start tomorrow morning at 9 o'clock. So we will try to be ready about 5 minutes early so we can make sure that we have a quorum moving forward. I will see you all tomorrow morning. Thank you.
Good night, everyone.
Ready?
Thank you.